My name's Laura Steele and I'm an associate in the commercial team. So today I'm going to talk about websites, logos and intellectual property. So as a general introduction, intellectual property protects creations of the mind. If you own intellectual property, it also stops other people using your intellectual property without your permission. Intellectual property is also a very valuable asset, so you can make money from your intellectual property. You can license your intellectual property rights to somebody else to use in return for a payment. Websites are made up of things like text, graphics, images, photos, software, the layout itself, and the main intellectual property right which protects those things is called copyright. Copyright is an intellectual property right which arises automatically on creation. So in order to qualify for copyright protection, it needs to meet the standard for originality. Now, that's not a difficult standard to meet, but you have to show that the thing that you've created was created through your own skill, judgment and effort. You also need to prove that it hasn't been copied from any other work. Copyright protection is aimed at protecting you from others copying your work. So if somebody does that, then they've infringed your copyright and you're able to take action against them. The general rule is that the author of the work owns the copyright. So what I mean by author is the person that took the photo, the person that wrote the text, the person that designed the graphic. There is an exception to that for employees. So employees that create an intellectual property right work during their employment with their employer, that copyright, for example, would be owned by their employer, unless there's an agreement to the contrary that says otherwise. As I said, copyright is owned by the author of that copyright. So it's a common misconception that if you pay a third-party consultant to create something for you, then you would own the intellectual property right in that work because you've paid that person to do it for you. In actual fact, they are the author of the work. So if somebody takes a photograph for you, they are the owner of that photograph, unless you have a contract in place with that party that says that you will own that copyright. So in the absence of a contract, you will only have an implied license to use whatever they've designed for you. So if you've paid a third-party consultant to create a website for you or to create a logo for you, if there's no contract in place, it's that third-party consultant that will own the copyright, not you. So you need to make sure that you have a contract in place that says what it needs to say to make sure it's transferred to you. I need to give a special mention to logos. So logos and branding are obviously something that form part of a website, and they will be protected by copyright. But it's important to note that the main intellectual property right which protects branding is trademarks. So you can have an unregistered trademark or you can have a registered trademark. So a registered trademark is a logo that's been registered at the UK Trademark Registry. Now, our advice to clients is always to make sure you register your logos as a trademark at the UK Registry, because it's easier to enforce a registered trademark than an unregistered trademark. And you would have the right to take action against somebody who used your brand without your permission. In conclusion, you should make sure that you've got contracts in place with any third-party consultants that create any materials for you, so logos or a website, to ensure that you own the intellectual property in the materials that they create. And if you do have any logos, you should make sure that you register them at trademarks at the UK Trademark Registry.